Nice micro Monday. Did the Software Freedom Conservancy conclude that Red Hat's business model violates the GPL? So Red Hat is the biggest commercial distributor of Linux, and by that probably the biggest commercial distributor of free software, and they are under a constant scrutiny from the community. And last year when they did some change on how they make the source code of their enterprise operating system, the Red Hat Enterprise Linux, or RHEL for short, available, a lot of people started to dive into their business model and try to figure out if whatever they are doing is conformant to the GPL license, which is the license for the Linux kernel and which is also the license for a lot of free software. And one of the issues that time was that as the RHEL source code is not available publicly, is that a problem? But generally that is not a problem because the GPL only makes you give the source code to those you give the software to. So you don't have to make the source code publicly available for everyone. You only have to make it available for those you give the software to. So that is not an issue, but the business model of Red Hat might have other issues. So in the blog post from the Software Freedom Conservancy, who's basically the biggest advocacy group for free software, they give us a summary on the business model that is in question here. And to summarize, basically what they do is that Red Hat offers you a service contract, and in this service contract they provide you with the operating system, the Red Hat Enterprise Linux operating system, and they bundle it together with the Linux kernel with user space utilities, graphical environments and user-facing software for their desktop solutions and server software for their server solutions. And they provide you with some kind of ongoing service. So if something goes wrong, you can call them and they will try to help you with troubleshooting and solving your issues. And they will provide you with updates for the software. But in their service contract, there is one important thing that is really giving bad vibes to the free software community, and that is that if you decide to redistribute the software that you receive from Red Hat, then they will terminate the service contract with you and they will not be doing business with you. So why is that a problem? So in the GNU General Public License, in the GPL, in the preamble, they say that, of course, when we speak of free software, we are referring to freedom and not price. And the GPL is designed to make sure that you have the freedom to distribute copies of free software. So if Red Hat gets free software that is licensed under GPL and they redistribute it in their Red Hat Enterprise Linux solution, then they cannot take away this freedom, because here the GPL clearly states that to protect your rights, which is the right of the user, we need to prevent others from denying you these rights or asking you to surrender the rights. So technically, based on this preamble, Red Hat cannot ask their customers to surrender their rights to redistribute the software. And then, of course, you can redistribute it, you can modify it for your own purposes, and then you can also redistribute the modified versions. Technically, if you receive free software that is under the GPL, you are allowed to copy it. So can Red Hat actually ask you not to copy it? Well, technically, they do not ask you not to copy it. They just tell you that if you copy it, then you won't receive any further updates, you won't receive their service for maintenance of your currently available software that you have. But, well, technically you can redistribute. At least that is their point they are making. And this is what many people say is the issue with the business model, that you may not impose any further restrictions on the exercise of the rights granted or affirmed under this license. So you may not impose a license fee, royalty, or other charge for exercise of rights granted under this license, and you may not initiate litigation, including a cross-claim or counterclaim in a lawsuit, alleging that any patent claim is infringed by making, selling, using, or offering a sale, or importing the program or any portion of it. So if we scroll down in this blog post here, this is the important part. So Red Hat's lawyers clearly take the position that this business model complies with the GPL, though we aren't so sure. So this is what the SFC lawyers say, that they are not sure. And the grounds are that nothing in the GPL agreements requires an entity to keep business relationship with any other entity. So basically, in the GPL, there is no promise that I will keep giving you updates of this software no matter what. Actually, the opposite is true. The GPL explicitly tells you that the software is provided as is, used at your own risk. And I guess the kind of the service contract that Red Hat gives you with the software is an additional thing to the GPL, in which they guarantee the software to work in this additional agreement, not in the GPL itself. So if you go further, that the business relationships can be terminated based on any behaviors, including exercising rights granted by the GPL agreements. So the GPL only covers the software itself, and while Red Hat will not be able to sue you if you redistribute the software you get from them, they can reserve the right of not continuing working with you because the business relationship is not covered by the software license. So whether this analysis is correct is a matter of intense debate, and likely only a court case that disputed this particular issue would yield a definitive answer on whether that disagreeable behavior is permitted or not under the GPL agreements. So this is what we have to consider here, that the United States, where Red Hat is situated, they have case law system, specific licenses, specific contracts can be tested in the court of law, and once there is a kind of a legal decision on a dispute like this, that is when basically we can know that probably in the future judges will also make the same decision based on this the system of precedents. So because there was no legal case on GPL grounds against Red Hat, we cannot know for sure if this works or not for them without breaking the GPL. So, of course, there is no doubt that this provision is not in the spirit of the GPL agreements, and the real business model is unfriendly, capricious, and cringeworthy, and I am quite sure that I mispronounced at least one of these words over here. So, I think to say that based on this blog post that the SFC found that Red Hat is breaking the GPL is a high overstatement. What they say here is that while technically they might conform with the GPL, it is not 100% sure. So it might be based on like a decision of a judge who is very much versed in the laws related to contracts and licenses, that has to make this decision once there is a lawsuit that will require a judge to make this decision. But what they say here, which is, I think, at least almost as important, so not making this decision that Red Hat is clearly breaking the GPL, I think it's kind of not the most important point of this blog. What is more important is that there are precedents, and not legal precedents, but just things that happened in the past where basically companies got into service contracts with Red Hat, and Red Hat also tried to get licensing fees from its customers once their customers used Red Hat's code in their own product, which is that is explicitly stated in the GPL, that you may not impose a license fee or royalty on others for exercising the rights to copy and redistribute the software. Oh, it is actually here also in the blog post. But in that case, they figured out, so someone got to a lawyer and they told Red Hat that, hey, you cannot get any license fees from us because the license that you gave us tells us that you cannot ask us for license fees. And there are some other violations here. So actually like two examples given in this article where they give specific examples where Red Hat broke the GPL license of software that they redistributed, but not the general business model that they use is breaking the GPL. So what is, I think, the most important point is that Red Hat is technically in the right with their general business process, but it is a very murky grounds that they stand on. Basically, the main issue they have with Red Hat, which I think is a reasonable issue to have with Red Hat, and I kind of agree with their assessment, is that they are dancing on the edge of the GPL compatibility with their business model. It is very easy to just take one additional step in the wrong direction and break these GPL agreements. And because most of their customers will not be really well versed in what actually the GPL license covers, they might get into situations when they are exploited, their ignorance of the licenses are exploited, and that is definitely not good. Okay, so I think this was my summary. I think we can conclude that the Software Freedom Conservancy actually did not conclude that Red Hat's general business practice breaks the GPL, but they concluded that that kind of business model can very easily lead to breaking the licenses, and that is bad. I think this is especially highlights that even, the GNU GPL license, especially the AGPL license, I think are really the best type of licenses for free software, because at least they require the people who redistribute them and modify the software and then redistribute modified versions of the software to keep them free software. This is very important point that to protect your rights, we need to prevent others from denying you these rights or asking you to surrender these rights, which is not something that other licenses like MIT and BSD licenses cover. But of course, the other side is also understandable. When you get free software, you can do whatever you want with the current version you get, but no one owes you the newest version. So if someone is still working on the software, they can decide not to give you the newest version. Of course, you might get it from someone else later. Okay, so I'll shut up now and I will see you next time. Subscribe, give me a like, and comment if you have any contentions down below, and I will see you in the next one. Bye bye. So here it is what happens when you are giving the free software in a binary form. So this is what I talked about in the beginning of the video, that that basically tells how you have to give the source code, and you don't have to make the source code public. You don't even have to directly bundle the source code. Actually, with the binaries, you can just give them a written offer that is valid for at least 3 years, or as long as you offer spare parts for whatever device you are selling the software with. So, of course, what I used to say is that it is technically covered by the GPL if you don't give the source code, but you tell them that you have to send me a fax, and then after I receive the fax, I will give you the source code printed on toilet paper. I thought that would be conformant to the GPL, but actually it's not, because it says that the corresponding source should be fixed on a durable physical medium customarily used for software interchange. So as long as we don't use toilet paper for software interchange, that is not a valid solution. So you have to use a USB stick, or just send over, or in an email or something. So that is very important, that it should be a machine readable form at least, so the source code can be used by the party you give them to. Basically, the thing is, you do whatever you want with the software, but keep the source code open for those that you give it to. I guess this could be the summary of the GPL in a very few words.